Greetings and thank you for joining us today for NCSL's 2013 Top Issues webinar series. My name is Donna Lyons, Group Director of the Criminal Justice Program at the National Conference of State Legislatures, and I will be moderating today's webinar. Each year, NCSL develops a list of the most pressing and important concerns on state legislative agendas. Today, we have a panel of NCSL issue experts that will discuss important and timely criminal and juvenile justice issues. This includes current corrections and sentencing actions, including justice reinvestment reforms. Many states have enacted policies that prioritize prison space, improve community supervision, and reduce recidivism. Allison Lawrence will talk about how states are analyzing and using data and making investments in strategies that have evidence they reduce crime and costs. Juvenile justice systems are being re-examined in state legislatures. Using research and national models, updated policies have objectives of achieving outcomes that are both positive for kids and cost-effective for states. Sarah Brown will highlight the key ways that states are realigning and rebalancing juvenile justice. Pretrial policy is a growing criminal justice interest in state legislatures. Many people arrested for and charged with a crime are eligible for pretrial release. Rich Williams will join us to highlight current state legislative interests and actions to make pretrial release safer and more effective. Today's webinar will include presentations by these panelists, followed by a questions and answers period. To submit a question, which you can do at any time, please use the chat feature on the right-hand corner of your screen. We will try to answer as many of your questions as possible. Thank you once again for joining us. I will now turn it over to Allison Lawrence, a policy specialist in NCSL's Criminal Justice Program, who will discuss key state corrections and sentencing issues.
Thanks, Donna. In recent years, costly prisons and high recidivism rates have prompted states to take a step back and look at how they operate their sentencing and corrections systems. As a result, we have seen a growing number of states adopting policies to curb prison growth, reduce recidivism, and control spending while improving public safety. These actions fall under the umbrella of a policy approach known as justice reinvestment. To date, 30 states have taken justice reinvestment steps. You may not be familiar with the term justice reinvestment, but you probably are familiar with the issues addressed and policies adopted under this approach. Justice reinvestment involves collecting and analyzing criminal justice data, developing and adopting policies that reduce prison growth, and redirecting corrections dollars towards community-based strategies. As we head into 2013, we do so with some results and evidence that a number of these reforms are meeting their objectives. Since the enactment of a 2010 law in South Carolina, the prison population has decreased by over 2,500 inmates, and in 2012 alone, the state has saved over $3 million. North Carolina closed 4 prison facilities in 2011 as part of their Justice Reinvestment Act, and savings from the closures is being reinvested into expanded community-based treatment programs. There is a formal Justice Reinvestment Initiative that provides support and technical assistance to states. This effort is led by the Bureau of Justice Assistance in the U.S. Department of Justice's Office of Justice Programs and the Public Safety Performance Project of the Pew Center on the State. I will talk more about this formal initiative in a couple of minutes, but first I'm going to highlight some of the sentencing and correction policy trends that we are seeing in states. States are making changes to their sentencing laws. Many of these changes aim to reserve prison space for the most serious offenders while diverting nonviolent, low-level drug and property offenders into community-based sentences. Increasing felony theft thresholds is one example of this change. Stealing a couple $100s worth of property, say a $500 bike, is a felony in many states. However, in some cases, that $500 limit was set 10 or 20 years ago, and it's not been adjusted as the price of consumer goods has increased. So smaller thefts that would have been misdemeanors when the law was written are now felonies. Over the last decade, about half of all states have made adjustments to their thresholds, like a 2012 Georgia law that increased the felony threshold from $500 to $1,500. States are also taking a look at drug crimes and penalties. The same 2012 Georgia law created degrees of possession based on the weight of the drug, with penalties increasing for higher weight. There are about 10 other states that have made changes similar to Georgia in recent years. The idea behind these laws is to distinguish between drug users who may be in need of treatment and could be safely supervised in the community from those more serious drug dealers who a prison sentence would be more appropriate. To correspond with the changes to who is going to prison, states are beefing up their community supervision options. They are providing courts and supervision agencies with viable alternatives to prison that hold offenders accountable for their crimes. These community-based treatment and supervision options are based on research and evidence of what works to reduce recidivism and increase offender success. States are employing these evidence-based practices to decrease the number of probation and parole violations that result in prison time. Known by various names such as swift and certain sanctions, graduated sanctions, or administrative sanctions, the goal of these policies is to quickly impose sanctions on offenders for breaking the rules of their supervision. And the more serious the violation, the more restrictive the sanction. States have authorized various types of sanctions that can be used, such as increased drug testing, reporting requirements, electronic monitoring, weekend jail stays, and secure facilities. Last year, Oklahoma created intermediate revocation facilities. These secure facilities provide 6-month intensive substance abuse and mental health services to probationers and parolees who have violated the rules. Over the past couple of years, a number of states have added a mandatory period of post-prison supervision. During the last 6 months to a year of the sentence, an offender is released to the community to participate in transitional support services, and supervision agencies are able to monitor these offenders during that initial return to the community. This is a time when they are most at risk for reoffending. States are increasingly requiring the use of risk assessments to guide supervision and programming decisions. Supervision agencies can direct more intensive programs and services on higher risk offenders while placing low risk compliant offenders onto administrative supervision. Assessments are also being used to identify and place offenders in substance abuse and mental health treatment. States are funding these risk assessments and other improved supervision practices with savings from reduced prison populations. In some states, a one-time allocation is made from the closing of a prison wing or a whole facility, while others have established statutory funding streams. The reinvestment of funds is helping to sustain the changes being made. For example, when the Colorado legislature reorganized their drug classifications and penalties in 2010, they required that the savings from fewer offenders going to prison and some serving shorter sentences be directed to community-based substance abuse programs. As of 2012, the state has saved nearly $1 million. Performance incentive funding is a type of state-local partnership that directs funds to local agencies to successfully supervise offenders in the community rather than sending them to prison for probation and parole violations. In 2009, California lawmakers used one-time stimulus funds to support local probation departments who developed evidence-based supervision strategies and treatment programs that are designed to reduce revocations to prison. Going forward, the localities receive a portion of state savings from decreased prison admissions. The amount of the funding for each county is dependent upon the rate of decline in revocations. During the first 2 years of the program, probation revocations have declined by over 30%, and during the current fiscal year, $135 million is being distributed to counties. States are also redirecting funds to things like victim notification programs and services, risk assessments, innovative policing strategies, and offender diversion and reentry programs. Many of the policies I just described are adopted by states as part of a justice reinvestment strategy. Justice reinvestment is a data-driven process to decrease spending on prisons and invest in resources to reduce recidivism and increase public safety. Sentencing and corrections data is collected and analyzed to identify drivers of growth in prison populations and costs. The data is then used to develop and adopt policies that safely lower prison populations and improve community supervision. Reinvestment is made to support innovative and evidence-based policies. A bipartisan multi-branch commission is often involved in the data collection and policy-making process. And in some cases, the commission will continue to oversee and evaluate implementation of the new laws. By measuring the impact, states are able to gauge whether or not they are achieving the desired results and can consider making additional policy changes. Many of the state justice reinvestment efforts are being supported by a public-private partnership of the Bureau of Justice Assistance in the Justice Department's Office of Justice Programs and the Public Safety Performance Project of the Pew Center on the State. The Bureau of Justice Assistance administers federal funds to states and localities, and Pew provides the technical assistance. The assistance provided generally includes a comprehensive analysis of corrections systems data, collaboration with and convening of state policymakers and other criminal justice stakeholders, and development of recommendations for policies that reduce costs and increase public safety. In addition, once states have enacted justice reinvestment reforms, funds are available to assist states with implementation. Continued assistance can include development of and training on risk assessment tools, improved supervision practices like swift and certain sanctions, and creation of data systems to collect and track results of the new measure. So is justice reinvestment on the agenda in 2013? We know that 5 states have introduced or are working through the policy development process right now. In fact, just last week, South Dakota's legislation was signed into law. Among other things, the new law requires evidence-based supervision, makes changes to sentences for drug and theft crimes, similar to what we've seen in other states, and it expands the use of intensive supervision programs in specialty drug court. Following sweeping reforms in Georgia's adult system last year, the legislature has turned its attention to juvenile justice. Legislation was introduced last week that applies a justice reinvestment model to juveniles. The legislature also may look at some additional adult measures that would expand on their efforts from last year. Part of the justice reinvestment process is to continue monitoring data in order to sustain the results, and Kansas has done just that. In 2007, Kansas was one of the first states to pursue a justice reinvestment strategy. And this year, a working group has put forth recommendations to build on and improve the reforms made in 2007. As Kansas and other states pursue changes to their sentencing and corrections systems, NCSL will continue to monitor and report on the progress. To find out more about what I discussed today and the latest actions in states, we have the e-bulletin, quarterly newsletter that highlights state action, new publications, and other issues of interest. The report, Principles of Effective Sentencing and Corrections Policy, is also a great resource. It was developed by a work group of legislators who are recognized leaders on these issues. These and other resources are available on NCSL's Sentencing and Corrections page. I'll be happy to answer any questions at the end of the presentation, or feel free to contact me after the webinar. Thank you.
Thank you, Allison. As a reminder, you can use the chat feature on the right-hand corner of your screen to ask a question, and we will get to those questions following the presentation. We will now turn our attention to juvenile justice. Sarah Brown is the Program Director at NCSL, and she will highlight key trends in juvenile justice policy.
Thank you, Donna. State legislative agendas in 2013 were also focused on juvenile justice reform, with approaches that provide for public safety and produce positive results for kids at lower cost. Today, we continue to see state after state working to improve its justice system for youth across the country. Already in 2013, 324 juvenile justice-related bills have been introduced to state legislatures. So what are the key juvenile justice priorities for policymakers today? First, keeping communities safe is always the #1 priority. A second priority is cost effectiveness. Today we see state legislatures investing in cost-saving approaches that still safeguard the public by treating and rehabilitating young offenders more effectively. Lawmakers Lawmakers also are interested in policies to reduce delinquency that hold juveniles accountable and promote positive youth development. Many policies today appear to reflect all three of these priorities simultaneously in state legislation. In order to fully understand current policies, I want to give a brief mention of past history in juvenile justice that has impacted where states are today. There was a sharp rise in juvenile crime and violence across the country over a 10-year period from the mid-1980s to the mid-1990s. This led to a national concern that the rehabilitative model of the juvenile justice system was not working. As a result, state legislatures in all 50 states passed laws holding more young offenders accountable through adult sentencing options. Since then, however, juvenile justice systems and laws have shifted in other directions due to several contributing factors. Most notably, in the past 20 years, there's been a significant drop in juvenile crime rates. In fact, in July of 2012, the Department of Justice released its latest findings confirming the steady decline nationwide in juvenile violence. Secondly, now more than ever, there is more and better research available to lawmakers on the causes of juvenile crime and what can be done to prevent it. Scientific research on the neurobiological and psychosocial elements that affect the development of adolescents has emerged. Such research suggests that juvenile offenders' limitations in several areas of decision-making can make them less blameworthy than adult offenders. At the same time, states continue to brace for prolonged fiscal problems due to the nation's current economic climate, and again, are exploring cost-effective approaches in justice systems to save money. So while states may be varying stages of their respective juvenile justice reforms, we do see that many common trends have evolved. Under NCSL's long-standing partnership with the John D. and Catherine T. MacArthur Foundation, we wrote and produced a report in 2012 that gives a decade-long review of state legislative trends in juvenile justice. This slide you see here shows the cover of the report. You can access this report on our juvenile justice webpage, and we can send you hard copies as well. So what are the trends we're seeing? The first and very significant trend is exploring ways to keep youth in the juvenile justice system and out of the adult criminal system. This is fueled again by the new focus on juveniles' developmental needs resulting from neuroscience, social science, and behavioral science research that illustrates that kids differ from adults in significant ways. What are some of the ways? Well, in the way they recognize and respond to risk, in the way they control impulse, in the way they are influenced by peers, and in their capacity for change. States are now applying this research and evidence to juvenile justice policies. For example, states have passed measures to expand the jurisdiction of the juvenile court through laws that raise the age of juvenile court jurisdiction. Laws are also reforming direct file and transfer laws to return discretion to the juvenile court. Just last year, Colorado enacted legislation to reduce the prosecutor's control over who should be tried as an adult, returning much of the authority to judges. There's also a legislative trend to address juvenile competency, where traditionally competency was focused only on adults in the criminal justice system. States are enacting statutory provisions authorizing findings of incompetence to stand trial based on developmental immaturity. In 2012, Michigan became the 16th state to enact a juvenile competency statute to ensure that youth understand the court process and make reasonable decisions regarding their case. As part of distinguishing juveniles from adult offenders, significant rulings at the federal level have reshaped juvenile justice policy in this country. The United States Supreme Court has used the adolescent development research as evidence to abolish the most serious punishment for kids, notably the death penalty in 2005, the sentence of life in prison without parole for non-homicide crimes in 2010, and most recently, in June of last year, the court ended mandatory sentence of life without parole for juveniles in the case Miller v. Alabama. This means that the more than 24 states that have mandatory life sentencing laws will now have to review and amend their laws this year. Thus far, in 2013, there are several pending bills addressing the Miller ruling in various ways. In Delaware, South Dakota, Virginia, Washington, and Wyoming. In 2012, 3 states, North Carolina, Pennsylvania, and California, passed laws responding to Miller. Another legislative trend has been increasing due process protections for youth involved in the system and making positive procedural changes for juveniles. Laws have required that quality counsel be provided for juvenile offenders at various stages of proceedings and have also prohibited juveniles from waiving their right to counsel. Other state activity has addressed the rights of indigent juvenile defendants by increasing juvenile defender resources for them and changing the process for determining their indigence. A growing trend in states is also adopting evidence-based practices and realigning fiscal resources from corrections to community-based programs. Evidence-based programs and policies in juvenile justice provide treatment to youth and their families that seek to improve behavior and emotional functioning. Such programs are supported by rigorous outcome evaluations that clearly demonstrate effectiveness. States are also diverting juvenile offenders from corrections toward local community-based programs. In at least a dozen states today, including California, Georgia, Illinois, New York, Ohio, Pennsylvania, and Texas, such realignment strategies are moving fiscal resources from state institutions to community and evidence-based programs with demonstrated success. Such reforms help save money and hold kids accountable in developmentally appropriate ways. Another legislative trend is addressing and treating the mental health needs of young offenders. Between 65 and 70% of the 2 million youth arrested each year in the United States have some type of mental health disorder. This map highlights the many states in the past decade that have passed laws to respond with more effective evaluations and interventions for youth who come into contact with the juvenile justice system. Recent policies have focused on providing proper screening, assessment, and treatment services, while other states have implemented mental health courts to provide intensive case management to youth. States are also reforming juvenile detention and correction policies. We have seen a real shift in detention. Laws have shortened detention time and explored meaningful alternatives to it. Other measures have required the use of risk needs assessment instruments to help make processing and placement decisions, and others have established uniform standards for detention centers. Georgia, Illinois, Mississippi, and North Dakota have enacted very recent detention reform laws. Regarding corrections, other laws have dealt with the increasing segment of the juvenile offender, female offender population by enacting statutes that require gender-specific programming to help with prevention, treatment, and rehabilitation for females who have very different needs than males. State policymakers today are also more attentive to the existing racial disparities in the juvenile justice system. This map highlights states that have legislatively addressed disproportionate minority contact, which is abbreviated as DMC. Several states have established committees and task forces to study and remedy DMC, while other laws have provided increased data collection, training law enforcement, or requiring minority impact statements. Similar to fiscal impact statements, minority impact statements seek to provide a greater understanding of a proposed law for minorities. The seventh and final trend I want to mention is addressing reentry and aftercare for juveniles. We see laws are providing improved health care services and community-based services for youth returning to their home communities. As part of successful reintegration into society, laws are also protecting the confidentiality of juvenile records with increased safeguards for education, employment, and other transitions to adulthood. States are also putting expungement procedures in statutes so that records related to juvenile delinquency cases are sealed, erased, or destroyed. So overall, the legislative trends evidenced over the past decade reflect a new understanding of adolescent development and the value of cost-benefit analysis of youth programs. Aligning fiscal responsibility, public safety, and positive outcomes for youth is the driving force behind juvenile justice reform legislation. For more information on 2013 juvenile justice actions, we invite you to use NCSL's Juvenile Justice Database, which the link is listed here on this slide. You can access the database from NCSL's Civil and Criminal Justice web collection and search pending or enacted juvenile justice measures by author, topic, year, keyword, or state. And please also watch online for announcement of an upcoming juvenile justice webinar in April and other events throughout the year. Thank you very much for your time and attention today. I'm happy to answer any questions when the presentations are all done, or feel free to contact me directly anytime at NCSL.
Thank you, Sarah. Now we will hear from Rich Williams, a policy specialist in the NCSL Criminal Justice Program. He's been tracking pretrial issues and will discuss those interests and actions in states.
Hello, everyone. As Donna said, my name is Rich. I'm going to talk to you about the next top issue in criminal justice for 2013, pretrial release. The term pretrial release encompasses the time between pre-arrest when a person somehow gets the attention of the police through the commencement of their trial, if it should get that far. Everything that could happen to them in between, including the processes of being charged, detained, or released, are the policies we are talking about within that phrase. During that gap of time, the defendant is innocent but not necessarily free, which makes it a delicate time for the justice system due to the importance placed on a person's ability to maintain their innocence till and if they are proved guilty. The goal of the policies surrounding this process, that is, the state interest, is to have the defendant return for their trial without committing new crimes or harming people related to their original alleged criminal activity, like victims or witnesses, while again enabling them to maintain their innocence. So let's take a closer look at how state policies address these goals and where the recent trends in state interest are. I'm beginning with an overview so that you can see what I'm basing this information on. In 2012, we tracked 404 measures related to pretrial release across 40 states, with 117 of those passing into law. On the map here, you can see the breakdown by state and by number of bills that were introduced versus those that were enacted. It gives you an idea of the overall geographic diversity. On this slide, there is a graphical representation of issues that were addressed the most in that collection of legislation. As you can see, release eligibility and conditions for release, the commercial bail industry, and pretrial services were the three topics most addressed for 2012. Here on this map are the preliminary numbers for the bills we are tracking in the 2013 session. So far, we are tracking 171 bills, including 47 that carried over from New Jersey in 2012, so 124 new for the 2013 session. We're expecting this number to increase over the next month or so, but here on the next slide, we can see what's trending so far. As you can see there, many of the same issues commonly addressed from 2012 continue to be of high interest in 2013, and the top three mentioned before are exactly the same, and those are where I'm going to spend the majority of my time, with a few other areas of legislative interest sprinkled in. Just a note, for the purposes of these graphs, the issues from the bills carried over in New Jersey are represented in the 2012 count, so they're not being given extra weight. All right. The issue most addressed in pretrial release over the last 2 years, or 14 months to be more accurate, is release eligibility. Who can be released and under what conditions? These determinations are made by judges and are informed by state constitutions and statutes, and their decisions essentially come down to an evaluation of whether the detained person poses significant public safety or flight risk. If it is thought that a detainee can be released without endangering anyone and returning for their hearing, then they can be released on their own recognizance, or in other words, their promise to return to court. Others have conditions placed on their release, and there are even some who have their release outright denied. The most common group of arrestees who have their release denied are those arrested for capital offenses where the likelihood of guilt is great. That's common language in state constitutions and statutes. For example, outright denial of release occurs or has occurred in instances like the Connecticut Cheshire home invaders and the Aurora Theater movie shooter. In most instances, however, bail can't be just denied, but conditions are applied to help ensure a defendant's appearance. These conditions may include attending programs, pretrial services, posting a financial sum, participating in drug testing or electronic monitoring, among other options, or a combination thereof. Over the last 2 sessions, a trend within eligibility concerns that has emerged is the consideration of 2 categories of detainees and appropriate conditions for their release should it be allowed. And those are undocumented immigrants and those accused of domestic violence offenses. Domestic violence crimes are often restricted or contain enhanced conditions because of the victim's close relationship with the accused and how that may impact a person's ability to act rationally. This propensity is what most bills in this area are aimed at addressing. For example, an enactment from Maine requires police to use a validated, evidence-based risk assessment tool to determine the likelihood that someone accused of domestic violence would commit new offenses if released on bail, and mandates that the officer who conducts the test send the results to the judiciary. Other laws in this area include using GPS to track defendants and the use of victim notifications to keep them informed of official decisions. For the most part, again, these laws are focused on the link between the accused and the victim and protecting victims. The measures addressing undocumented immigrants generally have a different focus, reasoning that undocumented immigrant status might make a person an increased flight risk. For example, a 2012 enactment from Tennessee deems a defendant who is undocumented a flight risk if they seriously injure someone in a traffic accident. The new law compensates for this increased risk by authorizing a court clerk to set monetary conditions on their bail higher than would normally be allowed. Of course, not all eligibility bills focus on these two groups. Many laws look at these issues from a different angle, focusing rather on the specific type of release. For example, a Louisiana enactment in 2012 restricted release on recognizance for certain offenses. Again, ROR is the defendant's promise to bill returned to court. Restriction for crimes including human experimentation, cruelty to the infirmed, and injuring or killing a police dog, among others. So the law makes it so that a person arrested for these crimes can only be released with conditions above ROR. Similarly, like these provisions specifics on ROR, other laws mandate or add nuance to financial bond to the Tennessee law that I just, or participate in programs for certain crimes. Moving on to another subset of policies within eligibility and conditions of release, I touched on a bit moments ago, are risk assessment. Risk assessment tools are used by some state courts to aid in the release decisions. In 2012, 15 risk assessment measures over 10 states were considered and 8 were enacted. The purpose of risk assessment tools is to help courts identify the likelihood a defendant will fail to appear at their hearing and gauge the potential danger they pose to the community. The idea is that pretrial risk assessment instruments use research-based objective criteria to identify these propensities so that defendants are more likely to with the appropriate conditions necessary to get them to comply. Some of the common factors considered in these tools include the nature of the pending charges at the time of arrest, their criminal history, their history of failure to appear, and history of substance use. A 2012 Delaware enactment that recommended the use of a pretrial risk assessment tool to inform their magistrates' release decisions also interestingly provided measures to refine their tool by using data derived from the outcomes on rates of rearrest and failure to appear to create bigger data sets which would be able to be analyzed for specific conditions of release under specific circumstances, ultimately the thought being to help their tool operate more efficiently and be more predictive. Moving on, technology is playing an increased role for release options. GPS, among other electronic monitoring, can be used to make sure defendants aren't violating conditions of their bail, like house arrest or being someplace they shouldn't. Again, those charged with domestic violence offenses are often subject to specific provisions and programs that feature electronic monitoring because it's a way to release them and make sure they are not harassed or getting close to their alleged victim or witness. Currently, there are 7 bills pending that discuss the use of technology for monitoring defendants, and 4 of them are targeted at those accused of domestic violence crimes. Another example of technology being considered so that you can see the variety of technologies in release decisions comes from New York. A bill there is weighing the use of an alcohol monitor that would need to be warranted as a condition of release for some charge with enumerated crimes, including vehicular assault and vehicular homicide. One more note on these measures, many of them pass the cost of the program and the technologies on to the defendants themselves to participate. Here's the second of our top 3 issues in pretrial release, and that's legislation impacting pretrial services. Pretrial services are ordered as a condition of release and offer supervision of defendants to improve public safety and increase the likelihood they will appear in court. Often they are run at the local or county level and can be administered by a separate pretrial services agency or the court or through the district attorney's office for that jurisdiction. Pretrial services often are where risk assessments are conducted, and then they share their report on a defendant with a judge. Many of the risk assessment bills that I just discussed from 2012 were in the context of pretrial service or are conducted in that way. While pretrial services supply general supervision, sometimes they also offer specialized programs to more targeted populations of offenders that have underlying issues likely to cause them to reoffend. For example, drug offenders and veterans are common groups addressed in legislation, in that type of legislation, due to the nature of their addiction or trauma and the way that it may alter their behavior if left unsupervised. Programs like these were considered in Connecticut, Florida, and Oklahoma last year. Before moving on, I want to point out that Alabama was particularly active in this area in 2012, enacting 7 new laws, many of which enabled a district attorney to create a general pretrial service agency or pretrial service programs in their jurisdiction. And now we are on to the last of our 3 biggest trending issues in pretrial, commercial bail, which currently operates in 46 states. When someone is ordered to pay a financial sum as a condition of their release, they can pay it themselves, have a friend or relative pay it, and if you're in New York or Rhode Island, you may qualify to have a nonprofit charitable bail organization pay it. But of all those options related to paying financial bail, and in fact, according to the Bureau of Justice Statistics, the most common type of condition for release and method for that release in general is the use of commercial bonds to pay financial bail, and it's been that way since 1998. Under a commercial bond agreement, the defendant pays a non-refundable fee to a bond agent who certifies to the court he or she will be liable for the full cash bond amount if the defendant fails to appear. I have broken this issue out in 2 parts. The first is legislation that addresses the business practices of sureties, bail bondsmen, recovery agents, and any other employees. And the second is the way that states license or require qualifications for these professionals. In 2012, 29 states considered 71 bills related to commercial bond business practices. Of those, 24 were enacted. Of the issues in those bills, forfeiture, or the process of the surety paying the court if the defendant does not show up for their trial, received the most attention. Now, while forfeiture applies to all sureties, I've included it here for professional bondsmen because of how closely it's related to business. The legislation in this area is focused on setting time periods for and standards for payment, and when money can be recouped upon returning a defendant to court after their court date. In 2012, California, Louisiana, and Tennessee enacted laws addressing this area. The second issue is on how bondsmen can solicit business. For example, a new Connecticut law doesn't allow bondsmen to get new clients in police stations or at courthouses. Other laws prohibit referrals between judges or attorneys and bondsmen, and yet others focus on honesty and standards for advertising on flyers and billboards. The last issue I want to address for this is bond premium, also addressed in the Connecticut law. And what that is the percent on a bond that a bondsman can charge a defendant before they will post bail for them. The trend here has been to set a minimum, usually around 10%, to avoid creating a bidding frenzy between bondsmen that has in some instances resulted in 0% down payment with finance. The thought behind this is that if the judge has set a financial sum, the defendant should have to actually pay something before being released. Now let's take a look at licensure and other qualifications the state use to enable a person to become a bail professional. Common regulations include education and training requirements, both before licensing and for continuing education, criminal background checks, and prohibiting certain other professionals like judges or attorneys from being bondsmen. For 2012, 52 legislative measures concerning bond professionals were considered in 22 states, with 17 being enacted. The recent trends in this area have focused on increasing licensing and qualification requirements. For example, Louisiana enacted a bill that heightens the requirements for participation in their bondsman apprenticeship program. Tennessee now requires anyone who wants to own a bonding company to have been a professional bondsman in good standing under another employer for at least 2 years. And Colorado changed their bondsman oversight responsibilities to their Department of Insurance, now also requiring that credentials be issued and carried. There's one other type of provision I want to address, citation in lieu of arrest. A citation is a written order in lieu of a warrantless arrest that is generally issued by a law enforcement officer that requires the person to appear in a government office or court at a specified time, thus skipping the arrest process. They are commonly used for traffic offenses, and at least half the states are using them for misdemeanors, and some even for low-level felons. Last year, Maryland enacted 2 citation laws, authorizing their issuance for certain misdemeanors and local ordinance violations that carried a maximum penalty of 90 days detention. In addition to authorizing the citation process, states are also interested in identifying violations that they don't want that process available for. For example, Maryland doesn't allow it for failing to comply with a peace officer, and a new Colorado law prohibits those accused of stalking from having this process available to them. When used, people who are likely to show up for their appearance, citations can lower jail populations and provide cost savings to counties and localities. In closing, our work on pretrial release is supported through two partnerships. One is with the Public Welfare Foundation, and on the slide here you can see one of our other work products under this is a magazine article discussing bail and pretrial release issues, which you can find on our website at the link provided. And we'll, coming soon, also have a comprehensive online database of pretrial release laws, so be on the lookout for that. We also have a partnership with the Laura and John Arnold Foundation, and through that we've been able to, and will continue to, analyze pending and enacted legislation related to pretrial release policy. And you can see, or I guess you can't see, the picture there, which is meant to be a picture of the first version of that, but there will be more on our website, and it's a little bit of suspense, so you can follow that link and find it on our page. The resources I just mentioned and future projects are housed on our pretrial release tab and webpage. The link is on the slide there, and there's also a snapshot, what you can see, of the pretrial release tabs and location on our main criminal justice page. That does it for me, so thank you for listening.
Thanks, Rich. Before we move into questions, which you can submit still using the chat feature on the right-hand corner of your screen, I would like to ask the panelists about a common thread I noted in your remarks, and that is risk and needs assessment. Allison, can you start by saying a few words more about the role of and reasons for risk assessment in some of the corrections reforms you talked about? And then Sarah and Rich, please jump in as well with regards to juveniles and pretrial populations.
Sure. Thanks, Donna. This is Allison. You know, risk and needs assessments are one of the evidence-based tools that states are adopting to help maximize scarce resources. Courts use them or use them in their decision-making process to decide who is best suited, those highest at risk for a prison sentence, and then those who can be safely diverted to less costly community-based programs. Probation and parole officers or other community supervision officers use these assessments to place offenders in programs, treatments, and services that address their underlying needs related to the criminal behavior.
This is Sarah again. Similar to what Allison has mentioned about the criminal justice system and risk needs assessments, it certainly similarly, again, applies to the juvenile justice system. I think it's important to point out that the rehabilitative aspect of the juvenile justice system places a real emphasis on the needs assessment part to ensure the needs of the juvenile can match the right services and interventions. So in the juvenile justice system overall, risk and needs assessment tools do help determine whether detention, institutional placement, or probation is even warranted, while also assisting with case management based on that individual use need to avoid unnecessary use of services if not needed. Risk needs assessments, again, are another way to deal more effectively with youth crime, delinquency, with the key being to lead to more effective intervention services for youth while conserving resources.
Risk assessments for release decisions, one of the interesting things I wanted to point out just for pretrial release, recent Delaware and Kentucky bills have added provisions related to collecting and analyzing the data that comes from rates of rearrest and also failure to appear, and ties them to the conditions that were put upon their release and the background information for each defendant. So in this way, it gives purpose-driven decision-making to the people making the release decision so that they have evidence supported behind what and why they're making their release decision for a particular person.
Thanks. Let's take some questions now. Sarah, I'm going to start with you. We have a question about the Miller v. Alabama case that ruled unconstitutional mandatory juvenile life without parole sentences. Our participant is interested in how states will deal with that, and in particular, what is NCSL doing on that issue?
Thanks, Donna. Well, that's a great and very timely question. We're getting lots of questions on this. So currently, what we have at NCSL is a sort of comprehensive document that deals with what states have done. As I mentioned, a few states passed laws in 2012, and we're trying to update weekly now what's pending in 2013. They all are pending as of now, but a handful of states have introduced laws too, and they're actually, dealing with it in different ways. So I think it's helpful for states to kind of see how other states are doing it. Everyone's sort of trying to develop the best approach. But that said, while we currently just have that available, we are planning on doing a larger piece this year, perhaps a magazine article or some kind of briefing as the issue sort of shakes out and more states weigh in on it. We will certainly do some programming as well, perhaps in our upcoming webinar, and then over the summer legislative summit, and the Legislative Summit is in Atlanta this year in August, and we'll do some juvenile justice programming there, and hopefully get some experts in to talk about the research, which states are interested in, as well as how they can amend their laws to comply with the ruling. So we have information, and we'll continue to build on information for our members.
Okay, thanks, Sarah. Allison, we have a question having to do with evidence-based practices, those proven to reduce recidivism. Do you have any references or resources on how states can find that information?
Yeah, that's a great question because evidence-based practices, there's so much science around it, and a lot of the resources can be a little overwhelming at times. But there are a number of groups that are collecting some of these resources and taking it into formats we can better understand. One of them is through the Bureau of Justice Assistance, and I would be happy to include a link to that. I can amend my presentation so that people can see the link to the BJA resource. Another good one is the Washington State Institute for Public Policy. It is a legislative entity associated with Washington State Legislature, and they have actually done quite a bit of studying on different programs and policies for both adults and juveniles on sort of what works to reduce recidivism, and they've taken some cost-benefit analysis of that as well. So that's also a great resource that you can use to loosely apply to your state as well.
Yes, thanks, Allison. I believe there's information online in a previous archived webinar that talks about the BJA Training and Technical Assistance Center and a database of evidence-based practice information that you can access via our website or follow up to Allison to get that direct link. We have a pretrial question. Rich, this has to do with the report on pretrial legislation that you mentioned. What all will be included in that? How comprehensive will that be, and what can we expect with that?
Well, those reports track, starting in 2012, any legislation that was introduced, and obviously includes enactments from 2012, and we're in the process of starting to do more on that in 2013. The database of pretrial laws will be comprehensive and include all laws already enacted, but that won't discuss previous years introduced bills that didn't pass the law.
Thanks. Another juvenile question, if I may, Sarah. Are there specific states to watch in 2013 where significant legislation is proposed?
Thanks, Donna. Yes, there are some states that take a look out, keep an eye on. Allison mentioned Georgia. had just actually last week, I believe it was February 8th, introduced legislation to revise and update their juvenile code. Several states last year, Kentucky and included, along with Georgia, had established task forces and commissions to study the effectiveness of the juvenile justice system. And this year are two states that we sort of have our eye on to see how that shakes out after spending the year studying it. And again, our juvenile justice database really gives you sort of the up-to-date kind of pending measures that are currently happening right out of the gate. Delaware, Hawaii, Massachusetts, Virginia comes to my mind as states of at least 10 to 15 bills already on various juvenile justice issues. So that's just a little bit of a sampling. But right now I would say kind of as far as big substantive reforms on my radar, keep an eye out for Kentucky and Georgia. Thanks.
Very good. Can I stick with you another minute here, Sarah? We have a question about reinvestment strategies in juvenile justice. Can you say anything about some of the more innovative approaches you're seeing in the states?
Sure. Yeah, it certainly is a very timely and hot topic, if you will, on states looking to kind of learn from how other states are reinvesting resources into community-based services. I would say, as I mentioned in my presentation, a couple of states to watch. Texas has done a whole lot of things there. Illinois, actually, back in 2004, put together Redeploy Illinois, which was sort of a cost incentive strategy, and they're a great model to look at. A more recent one is just in New York. In 2012, they enacted the Smart Investment Program through legislation to reinvest savings from reduced reliance that they're experiencing on juvenile justice facilities into community-based services for youth. So that's another state to look at. Ohio as well in 2011 in their sentencing reform bill, I believe included language to the effect that they said 45% of savings from closures had to be reinvested or wanted to be reinvested in community-based services. So states are doing it in different kinds of ways through different kind of bills and programs. Those are some of the top states, and I do have a lot of more information on that, that I can share with the questioner after the presentation.
Great, thanks. I'm going to move to another corrections question, if I may, Allison. What are states doing with inmate earned time or good time?
Good time and earned time in prison was something that we saw quite a few states evaluating and making changes to back in 2008, 9, and 10. But really in the past year or two, it seems like attention to that issue has been slowing down a little bit. But there is sort of a related policy that I've seen bubbling up in states. They've been turning their attention to these sentence credits for probationers and parolees. Credits are awarded for compliance with supervision requirements and to allow inmates to earn time off their sentence or to be placed onto more of an administrative level of supervision. Just last year, Delaware and Missouri both enacted laws that did this, and South Dakota's bill that was passed last week has also included this component, so I think that's definitely sort of a new reiteration of this type of policy that's being applied out there.
Great, thanks. We're going to move on to a pretrial question. Rich, if someone has a history of missing their court dates, can their release be denied for new crimes under these new policies you're talking about?
Well, that's going to depend from state to state and also on specific circumstances related to what the new crime is. How else they violate their condition of release for the original criminal activity. The first that's going to depend on is the strength of their active bail, from state to state. Different constitutions and statutory provisions provide ranging from what sometimes is referred to as a right bail down to other states that have more of, I think the language is usually generally just that there shall not be excessive bail. The states that are considered more right to bail through court interpretations, generally you can't just deny somebody's access to release because they've either missed their court date or committed a new crime. But that can be considered in the next release decision. Some states actually make that just missing your court date or violating your bail its own criminal penalty, for which also another release decision would need to be considered. But usually, I think for the most part, those are just weighed in the consideration for somebody's release, and enhanced conditions probably can be applied, because obviously it's going to negatively impact your ability to be released.
Thank you, Rich, and thanks to all of our presenters and all of you who asked questions. Let me start to wrap up by mentioning that if we did not get your questions submitted online, staff have your email address, and we'll follow up to you with your questions personally and promptly. And we want to thank you for joining us today. You will receive a short evaluation survey via email tomorrow, and we'll hope you take a few minutes to provide us with feedback about today's webinar. Also, an archive of the webinar will be available late next week on NCSL's website. We invite you to call on us in NCSL's Criminal Justice Program in Denver with questions on any of today's topics or any other criminal justice issues. The next webinar in NCSL's 2013 Top Issues webinar series will be on Friday, February 16th at 1 p.m. Eastern Time on budgets, taxes, and jobs.